Your phone knows where you are right now. It knew where you were this morning. It knows where you sleep, where you work, who you spent last Saturday with, and what time you went to bed. It knows this because every cell tower your phone connects to logs that connection, because every app on your phone that has location access has been building a detailed record of your movements since the day you installed it, and because that data is bought, sold, and in many cases, legally obtained by law enforcement without your knowledge or a warrant. The scope of American surveillance infrastructure became partially visible in 2013 when Edward Snowden released documents showing the NSA was collecting the phone records of every American, monitoring internet communications at the backbone level, and building a database of internet activity that included emails, chats, searches, and social media posts. What Snowden revealed was the tip of an iceberg. Since then, the capabilities of government surveillance have expanded dramatically through technology, legal interpretation, and the vast private data broker industry that sells location and behavioral data that law enforcement can purchase without a warrant. Stingray devices, officially called IMSI catchers, are portable technology that mimics cell towers to force nearby phones to connect to them, revealing the phone's location and capturing communications. Law enforcement agencies across the country possess these devices. For years, their use was kept secret even from judges overseeing search warrant applications. In multiple documented cases, law enforcement obtained general warrants that did not disclose they would use Stingray technology, which courts have ruled is a different and more invasive form of surveillance than a traditional phone tap. Thousands of people have been surveilled this way without knowing it. Automatic license plate readers are mounted on police cars, overpasses, and fixed installations throughout the country. They photograph every license plate in their field of view and record the plate number, location, date, and time. In jurisdictions with extensive ALPR networks, police can reconstruct the detailed movement history of any vehicle. This data is retained for months or years and shared between departments through data sharing networks. No warrant is required to collect this data because driving on a public road is not considered private activity. Your car's movements are a more detailed surveillance record than most people realize. Facial recognition technology is deployed at airports, by some police departments, and increasingly in commercial settings. The technology scans faces against databases and attempts to identify individuals. Its accuracy varies dramatically by race, performing significantly worse on darker-skinned faces. Despite this documented bias, it has been used to make arrests. In multiple documented cases, people have been wrongly arrested based on facial recognition misidentification. Detroit police arrested Robert Williams for a crime he did not commit based on a facial recognition match. The technology is expanding faster than the legal framework governing its use. Law enforcement agencies at the federal, state, and local level monitor social media as a routine investigative tool. The FBI, DHS, and military intelligence agencies all have programs that monitor social media for keywords, relationships, and expressions of political sentiment. This monitoring creates what constitutional scholars call a chilling effect. People who know they are being watched modify their behavior and expression even when they have done nothing wrong. The First Amendment was designed to protect political speech. Pervasive political surveillance undermines that protection without prohibiting any specific expression. The private data broker industry is the least understood component of the surveillance infrastructure. Data brokers collect information from app developers, loyalty programs, public records, and dozens of other sources to build detailed behavioral profiles on hundreds of millions of Americans. These profiles include location history, purchase history, social connections, and behavioral patterns. Law enforcement agencies purchase this data commercially, avoiding the warrant requirements that would apply if they collected it directly. A 2023 Senate investigation found that the data broker industry was selling highly sensitive data with virtually no oversight. The NSA has argued that collecting metadata, the records of who called whom, when, and for how long, is less intrusive than collecting the content of communications. General Michael Hayden, former director of both the NSA and CIA, stated in 2014 that the government kills people based on metadata. The patterns of communication, the network of relationships revealed by metadata, are often more analytically valuable than the content of any individual conversation. Knowing that someone repeatedly called a number associated with a particular political organization, at particular hours, from particular locations, tells a sophisticated analyst an extraordinary amount. The surveillance infrastructure is vast but not absolute. Encrypted messaging applications with end-to-end encryption prevent even their operators from reading the content of messages. Virtual private networks obscure internet traffic from internet service providers and some forms of government monitoring. Using cash instead of cards eliminates payment data trails. Turning off location services prevents app-based tracking, though cell tower data remains. None of these measures make a person invisible to a determined law enforcement investigation. But they meaningfully reduce the passive surveillance that captures everything about everyone continuously, regardless of any specific suspicion. The legal framework governing digital surveillance is decades out of date. The Electronic Communications Privacy Act, which governs government access to electronic data, was written in 1986, before email was widely used, before cell phones existed in their current form, and before social media existed at all. Courts have been slowly extending Fourth Amendment protections to digital data, but the process is fragmented and inconsistent. Legislative reform has been blocked repeatedly by law enforcement lobbying. The surveillance infrastructure that exists today was built in a legal framework that did not anticipate it. Reforming it requires political will that has not yet materialized. You are being watched. The question is whether you are aware of it and whether that awareness changes how you engage with the systems that are watching. The answer is not to disappear from the internet or to abandon your phone. The answer is to understand what data you are generating, who has access to it, under what legal authority, and to demand that those authorities be current, proportionate, and subject to genuine oversight. The surveillance state is real. So is the democratic tradition of pushing back against it. This is the Redacted.